Chair. Thanks a lot for the presentations. Obviously, since the last time we discussed this a few weeks ago, the directive has been watered down at European Council level under the impact of corporate lobbying, most significantly with basically it being up to member states whether they include the finance sector or they don't include the finance sector. So where countries don't, it would mean then that banks, other financial institutions wouldn't be subject to the requirements here, wouldn't have a responsibility in terms of environmental, social, labour rights. And obviously there's a real danger that that creates a race to the bottom between member states and a fragmentation of the market. So if I could firstly ask the Institute to comment on that, whether you think it's fair to exempt one sector from this process when other sectors are included.
Well, we didn't specifically ask that in our research. I think that one of the fundamentals in the legislation is a level playing field and to have clarity across the board. So I would imagine that over time, having everybody within the scope is probably going to be a positive thing. But we didn't ask that particularly within the research. The only thing that we did ask within the research and is we broke things down by sector regarding who oversees ESG related matters at the primary organisation and how often did they report on ESG goals and progress. And I suppose for the financial services sector, we did see that a healthy proportion of them were overseeing at board level, at full board level, ESG in their primary organisation, and just under half of them were reporting progress on an annual basis. Now, that compares reasonably favourably to the other sectors that we looked at, which were energy and resources, information technology, and healthcare and life sciences. But it's still less than 50%, and so I think it's good to have these snapshots in time, and I would be careful about extrapolating because the sample size was low for some of these sectors, but we would want to see that improving over a period of time.
Thanks a lot. If I could ask Mr. Linehan, when we had Dr. Rachel Widdis before us, she said that there is very little or no access to remedy for many of those who are affected by corporate harm. Could you maybe outline, well, one, whether you agree with that? I'm talking about someone, let's say hypothetically, an indigenous person living in the Amazon having their home destroyed as a result of an extractive process, which is like down the value chain, let's say, from a Irish-based multinational corporation. What prospect does that person have of seeking justice in Ireland? What kind of obstacles stand in their way?
Yeah. Well, one of the positive features of this, I thought, was that in elaborating on what the sort of just in explaining the whole prior due diligence kind of exercise and what it involves for the large companies who are covered, part of it does involve engaging with overseas stakeholders and indigenous communities, that obligation is in there as part of it. So, and the two complaint mechanisms that are the two complaints mechanisms that are in there, they're both in fact cover when various stakeholders, but including environmental NGOs and NGOs working in the human rights sector are entitled to make complaints directly to the company, and the company must set up a responsive complaints process and must account for how it deals with complaints. But the company can be bypassed and complaints made directly to a member state's competent authorities via an NGO or by any individual. And there's reasonably strong obligations around that. So, I think there are channels.
I'm talking about the kind of current situation.
Yeah.
And that this would mark. would potentially represent a significant improvement. But maybe to explore that further, the issue of the civil liability regime in the draft EU proposal, in order to make that workable, in order to have effective transposition of that into Irish law, are there changes that we would need to make? For example, you can't currently, as I understand, get legal aid for civil liability cases when your hypothetical Indigenous person is clearly not going to be able to afford to pay legal fees in Ireland.
You mean that they're really not going to be in a position to take legal action?
Under the current regime, yeah. I mean, they're not going to be able to take some major multinational to court in Ireland unless they get some sort of assistance with that.
Yeah, well, I would see that there's the opportunity in transposing this to address issues like that, and a lot of what's covered in this is environmental damage, actual or potential environmental damage, which is covered by the Aarhus Convention, and it's a really fundamental plank of that convention that there can't be over costly impediments to access to justice in environmental matters, and I think that will probably extend out into this regime. So I think that the cost barriers to access to justice in environmental matters are really starting to come down in this country, as we saw in the Supreme Court decision a couple of weeks ago in the Heather Hill case, which means now that there's in effect full cost protection for environmental litigants in every type of case. So I think, but I think issues like that will have to be addressed in the transposing measure as well.
Maybe just finally, the directive, as far as I understand it, it falls to member states to define the balance in terms of the burden of proof. Could you explore that a little bit, and how should we do it in your opinion?
Yeah, that's correct. It does fall to member states, but there's the core idea of causation, a causal connection. It says, for there to be civil liability for a large company covered by that for environmental or human rights damage, there needs to be a causal connection between their failure under this regime to do due diligence
and the consequences.
Yeah, and any damage, and a causal connection. And there are lots of EU environmental regimes that simply talk about causation, recognising that within the different common law, well now one common law and civil law regimes, there are slightly different causation tests. Some are slightly more strict, slightly more open than others in different member states. But so the traditional kind of just causation here, that there needs to be foreseeability, and that the action, there's just the connection between the action and the damage isn't too remote. So the kind of standard of causation that has built up in the Irish courts over decades of court cases, in everything from personal injuries cases to all sorts of other tort cases, will really be what applies here, I would think.
Okay. Thanks.